Good afternoon and welcome to this class of International Humanitarian Law. This afternoon I'll be taking up a new topic, which is International Criminal Tribunal for Rwanda and Sierra Leone's Tribunal. This is given in your syllabus also. So if you look at the syllabus, you can see that this is your syllabus. You see, this is your syllabus. And this is your syllabus, and if you look at this syllabus, you'll find that in topic number 4 it is this subtopic 4 and 5, International Criminal Tribunal for Rwanda and the Special Court for Sierra Leone. Both these are to be studied, and therefore you must be prepared for these topics also. So this is your syllabus. You see, this is your syllabus, and this syllabus, in this syllabus you have this course. So if you look at the International Criminal Tribunal for Rwanda, we will see that why this International Criminal Tribunal for Rwanda was needed to be established. As I told you, International Criminal Tribunal for the former Yugoslavia, that was created because when Yugoslavia was going to be broken up, at that moment of time, ethnic conflicts started, and during the conflicts, many serious violations of international humanitarian law occurred. And the international community, when they came to know about these reports of massive violations of international humanitarian law and serious violations of international humanitarian law, then they decided that they must act. And thereafter, I have told you that International Criminal Tribunal for the former Yugoslavia, that was established. Similarly, in Africa, there is one of the smallest countries of Africa, which is Rwanda. And this Rwanda is bordered by Uganda, Tanzania, and Democratic Republic of Congo, and Burundi. So this is a small African country, and which is densely populated. And in this country, there are two main ethnic tribes. First tribe is Hutus, and the second tribe is Tutsis. Now, these two tribes, they are not having good terms, and therefore, what happened that when the situation arose in 1990s, when Hutus, who are in majority, they planned a final solution to exterminate Tutsis. I have told you about these kind of bad policies which have been pursued by many regimes all over the world. And when I was taking up the lecture on International Military Tribunal at Nuremberg, I had told you that even there, Nazis, they had been pursuing the policy of extermination of Jews by pursuing the policy of final solution. So what kind of final solution is this? I am surprised. I always get surprised whenever I get reminded of these kind of solutions. You see that final solution. What was this final solution? Final was that they will exterminate the whole Tutsis. So then everything will be fine. So like if you have any problem in your home, suppose if an old person has become a liability, it is like final solution. So it's not like that. But these kind of policies have been framed all over the framed in some of the bad regimes of the world, and they have been detrimental to the international peace and security. So what happened that in 1994, reports of gross and systematic human rights violations in Rwanda by Hutus against Tutsis, those were reported, and it was reported that the Rwandan armed forces and the rebel Rwandan patriotic forces, they were having a very serious fight, and because of these fights, there were around 500,000 to 1,000, means 1 million people, those were reportedly killed. Now, if this is the kind of gravity of situation in a particular country, then what happens that international criminal tribunals, or at least international community, they become very much worried that how to stop such kind of situations. And thankfully, in this case, I have told you that in late 80s and early 90s, and afterwards, Security Council has been functional. Security Council, which is one of the principal organs of United Nations, that has become functional. And because Security Council had become functional in the 1990s, therefore, Security Council acted affirmatively according to the mandate which is given to it by the UN Charter. As you know, that United Nations Charter mandates the Security Council to determine any kind of threat to international peace and security, and also to determine any kind of breach of international peace and security. And after determining such kind of threat or breach of international peace and security, then Security Council has the power under Chapter 7 to take some affirmative action. And therefore, in this case, what happened, that Security Council wanted to prosecute those persons who were responsible for serious violations of international humanitarian law, which would ultimately threaten international peace and security. And thereafter, what happened, that United Nations Security Council passed a resolution under Chapter 7 of the UN Charter. First of all, it sent United Nations Commission of Experts. And finally, after the reports came from the Commission of Experts, it resolved to establish International Criminal Tribunal for Rwanda. And that was by Security Council Resolution 955 of 1994. In your examination, if you will write the Security Council resolution number by which this International Criminal Tribunal for Rwanda was established, you will get full marks. Because resolution, if you do not know, it's fine. But if you know, then you must write correctly. So 955 Security Council resolution established this International Criminal Tribunal for Rwanda. If you look at the composition of the offices, you'll find that it had a trial chamber, it had office of the prosecutor, it had the registry, and these all offices would function from a neighboring country of Rwanda, that is Tanzania, and appeal chamber of this Rwandan tribunal that would be established in The Hague. Even the registry of the appeal chamber will be at The Hague. So Tanzania is a peace-loving country, and Tanzanian, one of my students from Tanzania who had come to Delhi University Faculty of Law to study MCL course, and he told me about some of the things about Tanzania. So I know a little bit about Tanzania, and he was very, very brilliant, extremely brilliant student of MCL. So Tanzania is a country where the ICTR, Rwandan Tribunal, that's trial chamber was established. Now, if you look at the jurisdiction of the ICTR, then the jurisdiction of ICTR is given in the Statute of International Criminal Tribunal for Rwanda. So I told you that Security Council Resolution 955 established it. And how would ICTR function? ICTR would function on the basis of its own law. So that law is called Statute of ICTR. So in the examination, you will have to write the particular provision of ICTR which gives jurisdiction to ICTR. So if you look at ICTR, Statute of ICTR, you'll find that you'll find that the Statute of ICTR has some articles, and in Article 2, you see that ICTR statute. In Article 2, you'll find that ICTR statute talks about genocide. And if you look at genocide, you see this is the statute of ICTR, and you see this is Article 2, genocide. And if you look at genocide, because genocide is generally confused, you should not confuse genocide, because genocide is generally confused with massacres or pogroms. So it's different. Genocide means that if there is a intention to destroy, it's not always to kill. Massacre means killing. To destroy, intention is to destroy, either in whole or in part. And then the second important thing about genocide is that selection of a group, particular group, and those particular groups are also very, very clearly named in Genocide Convention, as well as verbatim reproduction of the definition of genocide in ICTY statute as well as in the ICTR statute. So Article 2 says that if there is a intention to destroy a group, and that group may be from four groups. First is national group. So if there is identification of a group on the basis of nationality, or if you select a particular group on the basis of ethnicity, like ethnical, if you select any group on the basis of their race, racial, if you select any group on the basis of religion, then thereafter you pursue a policy of destruction of that particular group, that may become genocide. So Article 2 laid down the jurisdiction of ICTR, and it said that there can be punishment for the commission of genocide. And then you'll find that Article 3, which talks about a different type of crime, which is called crimes against humanity. As I have told you in other lectures, that crimes against humanity are those kind of crimes which shock the whole conscience of the humanity of all the human civilization. And you see, if you look at this, it says that crimes against humanity is committed as part of widespread or systematic attack against any civilian population. So in crimes against humanity, it is always, what kind of act will shock the whole conscience of humanity when the civilian people who are unarmed, who are defenseless, if those kind of people, they would be killed by any kind of persons, then what will happen, that this may be crimes against humanity. So this is how, broadly what I have told you, but then it is exactly defined in Article 3 of ICTR statute as crimes which are committed as part of widespread or systematic attack against any civilian population on some certain grounds, like national, political. So political was not there in genocide. In crimes against humanity, political is also included, ethnic, racial or religious grounds. And then you see the list of acts which may be called crimes against humanity, like murder, like extermination, like enslavement, like deportation, like torture, rape, persecutions on political, racial or religious grounds, or other inhumane acts. So you see that this was also coming under the jurisdiction of ICTR. And then Article 4, which talks about the violation of Article 3, which is common to the Geneva Conventions and of Additional Protocol 2. I have told you that Additional Protocol 2 will be only applicable when there is a conflict which is non-international armed conflict. And then Article 3, which is common to all the 4 Geneva Conventions. What is Article 3? Article 3 also deals with the basic rules which will be applicable on non-international armed conflicts. So this is a tribunal which was established, unlike ICTY, where the conflict was international in character, but the Rwandan armed conflict was non-international in character. And therefore, the Rwandan armed conflict will have a different kind of statutory provision, in which Article 4 says that violations of Article 3, which is common to the Geneva Conventions, that would be punishable. So if you look at Article 4, you'll find that the serious violations of Article 3 common to the Geneva Conventions and of Additional Protocol 2, those are like violence to life, like collective punishments, taking of hostages, and then acts of terrorism and outrages upon personal dignity, and like rape, like enforced prostitution, and any form of indecent assault, and then pillage, and then some other things which you can see in this. So you see that there were these crimes which were there, and then Article 5, which says that personal jurisdiction, this ICTR will exercise personal jurisdiction. Article 6 says that there will be individual criminal responsibility of a person and it will not matter if the person is the head of a state or the government or as a responsible government official. So again, continuing the trend of Nuremberg trial, Tokyo trial, Yugoslavia trial, now this Rwandan trial was again confirming the trend that individuals can be prosecuted by such criminal tribunals, even if the perpetrator happens to be the head of state or head of government or responsible government official. So you see that these are some of the provisions which are important in the Statute of International Criminal Tribunal for Rwanda. And then you will find that what was the time period jurisdiction, what was the jurisdiction in terms of time which was given to Rwandan tribunal. You'll find that if any alleged criminal perpetrator of crime who had committed crimes between 1st of January 1994 to 31st of December 1994, only those people would be indicted by ICTR. Not so the jurisdiction was very much limited in time. So subject was very broad, but time period was very limited. So it was given only 1 year of time in which it had to see that how many people committed these kind of crimes. So you see that this tribunal, which was established in mid 1990s and which continued till just 5 years back. So 2015 end, it was functioning. So almost 20 years it functioned, and in 20 years it completed trials and appeals in 75 cases. So it's not a very bad kind of track record. And out of 75 cases which it heard, 61 people were convicted and 14 acquitted. So very important, because normally people say that again this is a trial which was a trial by the victorious ethnic tribe, but here it was not the same thing, because the majority of ethnic tribe was Hutus, and Hutus had committed crimes. So this is a completely different kind of argument here, that 75 cases, majority of most of them were from the Hutus tribes, and 14 of the Hutus were acquitted also, and then 10 cases were referred to national jurisdictions. So you see that this is how this ICTR was established, and this is how this ICTR was given the jurisdiction, and this is how this ICTR was given the power to start the trial. And out of, I told you, out of 75 cases that it heard, I have selected some of the cases, and because I don't have too much time to discuss about Rwandan tribunal, so what I will do that I will just take up one case, which is the case of Kam Banda, and other cases I will just refer to in between when I will discuss about the contribution of ICTR. So what I will tell you that the first case that I am going to discuss is the case of Kam Banda. And why I am going to discuss this case of Kam Banda, because Kam Banda was the person who was the very, very powerful person of Rwanda. And not only did he belong to the majority tribe, Hutu, but he also was the interim prime minister. And look at his career. He was an engineer, and then he became a politician. So an engineer turned politician, and not only just any kind of politician, but he became the interim prime minister of Rwanda. But you look at his behavior when he became the interim prime minister. He was knowing that these kind of conflicts are going on, and people are going on to kill the Tutsis, and they have the policy of final solution. So as an interim prime minister and as a level-headed prime minister, what Kam Banda should have done, Kam Banda should have stopped it, because he was all powerful, and Kam Banda should have done all the things by which he could have prevented the commission of these acts. But he did not do it, and therefore when this ICTR was established, he was charged with the commission of genocide and also crimes against humanity. And one of the main one of the main arguments which was taken up by the prosecutor of the Rwandan tribunal was that he didn't take any step to stop the course of genocide. But one of the very good thing that happened in this trial, that at last Kam Banda's good personality prevailed over him and during the trial. And what happened that when he was asked that, okay, do you plead guilty or not? And then what he said, that he said, I plead guilty. Normally, the people who are brought before the trial, they say not guilty, and then the trial starts, because then the accused has to prove that how he is not guilty. So Kam Banda said that he is guilty, and thereafter it became a little bit easy for the judges. And what happened that finally the judges said that he should have been given even very different kind of tough punishment, but he was sentenced to life imprisonment. Right? So because as an interim prime minister, he didn't do anything. Right? So this is one of the example by which I just wanted to tell you that the international criminal law has now the strength to even indict and to try and to prosecute very high and mighty people if they are involved in the commission of crimes of international gravity. And after, so there are so many cases which were decided by International Criminal Tribunal for Rwanda. If you want to go in further detail, you can you can read my book, which is Theory and Practice of International Criminal Tribunal for Rwanda, and then you will find that I have tried to explain the subject matter jurisdiction, and then you will see this is my book, and you will see that some landmark ICTR trials I have discussed. So you will see that prosecutor versus Akayesu, and then so many trials I have discussed. You see, and that the second trial that I have discussed is Kam Banda. You see, this is the Kam Banda case that I have just discussed with you, and thereafter you'll find so many cases, prosecutor versus Nahimana, that I will discuss little bit later. So this is how you see that if you want to look at further, then you can read my book also. Now I will move on to the contribution of this Rwandan tribunal, and you will find that Rwandan tribunal has contributed a lot in the development of jurisprudence of international criminal law. If you look at some of the, so I have selected some of the few judges who have contributed a lot to the development of international criminal law. My selection may be very subjective, but I thought that because of the fact that Rwandan tribunal have given a very good number of judgments in which they have created a good thing, like how they interpreted that how rape should not be used as a weapon of war, and how outrages upon the personal dignity of women that should not be there during the times of armed conflict. So these are the things which have attracted me more, and on that basis I have selected some of the judges' contribution. For example, like Navanitham Pillai. Look at her. She is there on the slide, and Navanitham Pillai's judgment as the ICTR president during 5 years, and then she was a judge for the 8 years, and she was the judge from South Africa, but she was there in ICTR, and she was the judge who had the courage to acquit one of the accused, Bageli Shema, and she was the judge when the ICTR other judges visited the place of crime. So it's not normal. Normally what happens that the tribunal judges, particularly when the criminal tribunals are such which are going to prosecute serious crimes, where the judges are thinking that why to go to the place of crime because it's not very safe. But then in this case of Rwandan tribunal, you will find that judges visited even the place of the crime and to collect the evidence. Sometimes you might have heard that the judges of our country also, judges from High Court and Supreme Court, they have done such kind of exercise by which they have also visited the place of the scene of the crime or place of the place where the incident might have taken place, and to collect themselves evidence if they have in their mind, if there is any kind of doubt. So in Navneetham Pillai's example is such kind of example. And I should also tell you that she was also the judge in a trial, which is Nahimana trial. In that trial, she was one of the judges who held the media responsible for international crime. And it's not normal to say that media people can be held responsible, because they will say that what the government is doing, that they were also doing. But then what she said, if I take you if I take you to my book, you'll find that I have discussed this Nahimana case, and you'll find that this Nahimana case, how in this Nahimana case was important. And you see that this person, Ferdinand Nahimana, was an academic, and he was also the founder and principal ideologist of this radio television library des Miles Collins. And then he was also, there was another person. They were all held liable because these people, they were uh, they were not uh, uh, propagating any news by which they could have pacified the whole armed conflict, the whole ethnic tribes which were fighting against each other. So media had also a role, and that was emphasized by Navneetham Pillai and the other fellow learned judges. Other judges from Rwandan Tribunal were Jairam Reddy from Fiji and Khalida Rashid Khan from Pakistan. They have also contributed to the jurisprudence of International Criminal Tribunal of Rwanda. How this is a very important contribution, because this was the first tribunal to discuss rape as crimes against humanity and also as genocide. So before that, rape was not considered as crimes against humanity, or rape was not considered as genocide, amounting to genocide. But this was for the first time that the tribunal held in Akayesu, in Gakumbitsi, and Karamara cases, that rape may amount to crimes against humanity and rape may amount to genocide. And this was also the tribunal which also did a lot of new things, like shielding the name of the real name of rape victim from to the outside world. So using pseudonym, and then it also allowed in-camera proceedings, which is also now it has become a new standard for the trial of the rape victims all over the world. So you see that this is how we should, in a brief way, we should try to understand International Criminal Tribunal for Rwanda. Now, I'll be moving on to the next tribunal, which is a different type of tribunal. So right now, till now, I have been discussing with you ad hoc criminal tribunals. So ad hoc criminal tribunals are those tribunals which are established to look after a particular situation which was created. So for ad hoc kind of tribunal means that it will remain not for permanently. So it will be only for a small time. It will remain there, and it will do its duty, and then finally it will be dissolved, right? And second important thing about the International Criminal Tribunal was that it was not established in the country where the crime took place. Crime took place because of the fact that in that very country it is very difficult to hold the trial. So this was one of the thing, and third important thing was that international criminal tribunals, they were given primacy over the domestic courts. So whatever the judgment of these tribunals will be there, they would be having supremacy over the other judgments of any other courts of that country. So these were some of the important features of ad hoc criminal tribunals. Now I will take you to another kind of tribunal, which is kind of mixed tribunal. And this is the example of Sierra Leone's tribunal. And that Sierra Leone tribunal is a tribunal which is a different kind of tribunal. And the name of this tribunal is Special Court for Sierra Leone. Special Court. And where is Sierra Leone? Sierra Leone is a West African coastal state. And in this West African coastal state, there are 75% Muslims and 23% Christians. This country, small country, is famous for diamonds, gold, and bauxite. Sierra Leone is also famous for a famous judge whose name is Abdul Koroma. He is one of the longest serving judge at ICJ, International Court of Justice from Sierra Leone. However, Sierra Leone had a very difficult and turbulent time during 1990s. I don't know why, but 1990s were a kind of very difficult phase for most of the parts of the world. Since March of 1991 in Sierra Leone, there was a civil war which started. And in that civil war, there were different groups which were formed. One of the group was led by Fode Sanko, and that group was called Revolutionary United Front. And this group was supported by Charles Taylor, who was the president of the neighboring country, which is Liberia. And then another group was pro-government, and that is Civil Defense Force, and that was working under the leadership of Sam Hinga Norman. And there were some other groups like Armed Forces Revolutionary Council, and then one-party military regime of All People's Congress. So these groups, they started fighting against each other, and this civil war had started in Sierra Leone. And again, ultimately, the victims were the common people, the civilians. And then what happened that when one of the group, which was led by Fode Sanko, seized power in 1997, civil war intensified. Reports all over the world, world reports came about widespread atrocities against civilian population, and particularly mass rape, abduction of women, forced recruitment of children, summary execution. These kind of reports which were coming to international media, and by which international community was alarmed. And after that, you'll find that at the international level, United Nations level, again, Security Council acted, and United Nations was requested by the Security Council to intervene. And then after that, a peace agreement was signed in 1999 between United Nations Secretary General and then RUF, and then democratically elected government. And thereafter, after this lone peace agreement was signed in 1999, government of Sierra Leone requested the United Nations to establish a tribunal to prosecute the perpetrators responsible for violations of international humanitarian law. And ultimately in 2000, an agreement was signed between the government of Sierra Leone and the United Nations to establish special court in Sierra Leone. And thereafter what happened that this special court was created in 2001, and it started working since 2002. If you look at this special court of Sierra Leone, it is the example of mixed tribunal. Mixed tribunal in the sense that United Nations had a role to compose this tribunal, and Sierra Leone, where this tribunal was established, Sierra Leone was also having the role in the composition of the tribunal. So this, and then subject matter was not the Sierra Leone's penal code, but subject matter was a different kind of international criminal law, which was having genocide, which was having crimes against humanity. So it was a kind of internationalized courts. Then you will ask the question that why is it that uh, sometimes international criminal tribunals are formed and sometimes mixed tribunals are formed? The answer is that whenever the national courts are having the potential to prosecute the perpetrators of international crime, in such cases, international community may establish the mixed tribunal because they may know that the domestic courts may prosecute such perpetrators. But if they do not have the faith in the national courts, if the international community, if they will not have the faith in the domestic courts, and if the government of the state is not having the faith in its own domestic courts, in such case, what will happen that international community has no other option than to establish an international criminal tribunal. So in this case, what happened that the government of the day, it kind of gave assurance to the United Nations that their domestic court that will also help in the prosecution of the perpetrators of international crimes. And thereafter, United Nations agreed, and then this mixed tribunal was established. Now, if you look at this jurisdiction of this special court of Sierra Leone, you'll find that again the jurisdiction is given in the statute of the Sierra Leone's special court, and this is the Sierra Leone's special court statute. And if you look at Article 1, it says that this court has the power to prosecute persons who are most responsible for serious violations of IHL and Sierra Leone's law committed in the territory of Sierra Leone since 30th of November 1996. So if you remember, I told you that this civil war had started since 1996 itself. So the court's jurisdiction was since 1996. And then it had the jurisdiction over crimes against humanity. So crimes against humanity is an international crime. So crimes against humanity, how is it defined? Again, it is defined as a little bit different from ICTR. In ICTR, if you remember, crimes against humanity could be committed only against some of the groups. But here, it is not the groups which is important. It is simply saying that crimes which are committed as a part of widespread or systematic attack against any civilian population. So this is a better statute, should not have limited the commission of crimes against humanity vis-a-vis only certain groups. So the Sierra Leone's special court statute, it is advanced one, and it says that any kind of widespread or systematic attack against any civilian population, including murder, extermination, enslavement, deportation, imprisonment, torture, rape, sexual slavery, forced prostitution, forced pregnancy, and any other form of sexual violence and persecution and other inhumane acts that will be punishable and as crimes against humanity. If you look at Article 3, it says violations of Article 3, which is again common to the Geneva Conventions and of Additional Protocol 2. So this is very much same as ICTR statute, because this is again in Sierra Leone, the civil war took place. So this was non-international armed conflict. So in non-international armed conflicts, Additional Protocol 2 is violated, and then Common Article 3 of the Geneva Conventions that is violated. So Article 3 is again saying that, and Article 4 says other serious violations of IHL. So Common Article 3 is the very basic one. If that is violated, it becomes a very, very serious thing. And then Article 4 says other serious violations, and there you'll find that what we have learned in the choice of and the means and methods of warfare, you'll find that here it is mentioned that if somebody intentionally directs attack against civilian population as such, or against individual civilians not taking active direct part in hostilities, or someone intentionally directing attacks against personnel, installations, materials, vehicles involved in humanitarian assistance or peacekeeping mission in accordance with the Charter of UN, then it may be serious violation of IHL. And then suppose somebody is involved in abduction and forced recruitment of children under the age of 15 years into armed force or groups for the purpose of using them to participate actively in hostilities, that will become serious violation of IHL. So these are the things which you must know, that in the statute of Sierra Leone's special court, the jurisdiction is mentioned, and you see all these. Article 2 tells you about the crimes against humanity. Article 3 tells you about violations of common Article 3 of Geneva Conventions and of Additional Protocol 2. Article 4 talks about other serious violations of IHL, and Article 5 talks about crimes against Sierra Leone's law. And if you look at the structure of this special court, you'll find that there were 2 trial chambers, and in each trial chamber 3 judges were there, and there was 1 appellate chamber in which 5 judges were there. And why it was a mixed tribunal, why it is called hybrid tribunal? Because I told you that the domestic state has also a role in the composition or creating the structure of the court. And in this Sierra Leone's special court, Sierra Leone had to appoint 1 out of 3 in each trial chamber, and 2 out of 5 judges in the appellate chamber, and Sierra Leone had also the power to appoint 1 deputy prosecutor. And the remaining vacancies would be filled by the United Nations. For example, prosecutor or registrar, they would be filled up by the United Nations. So in this way, what you must understand, that this was a special court which was the example of first international crimes, which was the example of first hybrid tribunal in the whole world, which was located in Freetown, which is in Sierra Leone, except one of the trial of Charles Taylor, just I am coming after this slide, which took place in The Hague, which is in Netherlands. Now I will again bring you to the Charles Taylor's trial. I have told you about Charles Taylor. I have told you about Charles Taylor, that who was Charles Taylor? Charles Taylor was the president of Liberia. Liberia is a neighboring country of Sierra Leone, and you see this is the person who is Charles Taylor. So in August 1997, Taylor was elected president of Liberia, but what he was doing, he was also involved in assisting and encouraging the rebel group in Rwanda, in Sierra Leone, which is the Revolutionary United Front that I have told you, and AFRC. These were the groups whom Taylor supported. And what happened, that not only he supported, but he had also given all kind of support by sending arms and ammunitions. And then what he did, that he was also involved in saying that, okay, you can commit any kind of crimes, and that too international crimes. So the whole civilians, they were terrified. So terror, so they used terror. Fode Sanko, that I mentioned you, this Charles Taylor, Sam Hinga, even the government-led forces, they all were, what they were doing, that they were fighting amongst themselves. And what they had in mind, they wanted to have control over the government. And why? Because I told you that it's a place of diamonds, bauxite, gold. So every group was fighting for all these, scarce resources. So, but in doing that, what they were doing, that they were going to commit any kind of crimes, and which was ultimately, making civilians as victims. So what happened, that when Sierra Leone's special court was established, then Charles Taylor was also indicted. In 2003, he was indicted by this special court when he was serving as a head of state. That is very important. So is this the strength of international criminal law? That international criminal law can also prosecute a serving head of a state? So that is how you see this trial is important, that this head of a state was charged with committing crimes against humanity and also violations of Common Article 3 of Geneva Conventions and of Additional Protocol 2, and other serious violations of international humanitarian law. And this man was tried. First of all, he was indicted, and thereafter he was arrested. And it was very difficult to arrest him. But however, when the international community supported, when the Sierra Leone government and the Nigerian government and other governments of Africa, they supported in the arrest of Charles Taylor, only then he was arrested. And once he was arrested, trial started, and trial took place for 5 years, and he was ultimately held guilty, and he was punished for 50 years in jail. So now Charles Taylor is serving the punishment. So you see that what I was going to tell you, that international criminal law has grown from what we say, just from nothing to now a very, very heavy stalwart thing, right? That it has the potential to prosecute such kind of persons who are very, very powerful. Now I will move on to the last slide, which is that how this special court has contributed to the development of international criminal law. And I will tell you that the special court was indicting 23 high-profile military commanders and leaders. And if you just to name a few, Fode Sanko, Sam Hinga Norman, and Charles Taylor, these were the most powerful persons during that time who had been involved in perpetrating these kind of international crimes. So out of these 23 people who were indicted and who were tried, 3 were acquitted also, and 16 were punished. 4 died. So it's not a case that all the persons who were indicted, they were all punished. 3 acquitted also. More important than these things, these factual things, are that this special court, if you look at the statute of this special court, I have just shown you that crimes against humanity for the first time included sexual slavery, enforced prostitution, forced pregnancy, and any other form of sexual violence. If you look at other statutes of ICTY and ICTR, you'll find just a reference to rape. But this is the first kind of statute of a special court which explained and further, developed that how crimes against humanity is committed if it is committed through rape as a weapon or sexual slavery as a weapon. Because Charles Taylor, Fode Sanko, they were all involved in such kind of mass rapes and mass sexual slavery, such like that. And other important contribution of Sierra Leone's special tribunal was that other serious violations of IHL included the recruitment of child soldiers. So this was not there in other statutes, child soldiers, because for the first time international criminal law had to learn from the Sierra Leone example that how many children they were recruited during the civil war in Sierra Leone. So therefore, in this statute, what happened that this was also incorporated, that recruitment of child soldiers may amount to serious violation of international humanitarian law. And finally, if you look at the contribution of judges, I have again selected some of the judges, like Julia Sebutinde. She was from Uganda, and she was very forcefully and assertively, she was saying that rape should be, the definition of rape must be broadened, and we must give full meaning to the words which are used in the statute of Sierra Leone Special Court. And also the judge from Nigeria, Emmanuel Ayula, he was also very, very assertive in punishing the people by fully giving full meaning to the words which are used in the statute, in the charter of Sierra Leone. Richard Lusik, he was from Samoa. Samoa is a very small island nation. So he was from Samoa, but Richard Lusig, they were there during the Taylor's trial also. And in Taylor's case, if you read the Taylor's case, then you'll find that it developed a lot in the in developing international criminal law. So today, what I wanted to make you understand that the experience at the world level has been not only by establishing one kind of tribunal, but also different experiments have been done. At one level, ad hoc international criminal tribunals were established. At other level, hybrid or mixed tribunals have been established. And I could not take up the Cambodian example, where in Cambodia also the hybrid example was set up. There also, if you look at Cambodia, you might have heard about Pol Pot, who was a very dictatorial, who was having dictatorial regime, and he was responsible for commission of, crimes against humanity, and also serious violations of international humanitarian law. And Cambodia, in Cambodia, what was happening that extraordinary chambers were established by the United Nations. So that is also the example of mixed tribunal. So the thing is that in different places and in different times, the international community has established different types of courts and tribunals to prosecute. But the important point is the whole objective has been to prosecute those persons who are responsible for committing international crimes of serious nature. So this is how I will stop here, and I will thank you for bearing me, and wish you a safe and healthy stay inside home.